Section 8 of the RP Act deals with the disqualifications. We'll have to see the import of Section 8 and how courts have looked at Section 8 from day one and up to the latest decision being rendered in Pradeep Kumar Sontalia, reported in 2021 6 SCC 523. I think we have to go to Section 8 as the statute provides for it. Section 8 deals with disqualification on conviction for certain offences. So the origin of disqualification under RP Act is the conviction entered upon by a court of competent jurisdiction on certain offences. A person is convicted. See, for example, Section 8(1) itself refers to the various offences which are likely to, when convicted, which are likely to result in disqualification. They are set out in Class 8, subsection 1, Class A, deals with offense promoting enmity between the different groups or on ground of religion, race, place of birth, residence, and the like. Now, Class B, Protection of Civil Rights Act 1955, which provides for punishment for the preaching and practice of untouchability. Subsection C says the Section 11 of the offense of importing and exporting prohibited goods of the Customs Act. Then the various sections will deal with it. We can go to subsection 2. A person convicted for the contravention of law providing for prevention of hoarding and profiteering or any law relating to adulteration of food or the provisions of the Dowry Prohibition Act. Subsection 3 of Section 8 would deal with this. A person convicted, this is the consequence. A person convicted for any offense and sentenced to imprisonment for not less than 2 years, other than the offences referred to in subsection 1 or subsection 2, shall be disqualified from the date of such conviction and shall continue to be disqualified for a period of 6 years since his release. This is the crucial section that falls for determination or for discussion by us this evening. Please note, Section 8(3) would say that a person convicted of any offense and sentenced, the two things are there. He must be convicted and he must also be sentenced to imprisonment for not less than 2 years, other than any offense referred to in subsection 1 or subsection 2, shall be disqualified from the date of such conviction and shall continue to be qualified for a further period of 6 years since his release. Please note the language of the statute. It would say that if he is convicted of the offense and he is sentenced to imprisonment of not less than 2 years, the minimum term for which he is imprisoned is 2 years, then that is the basic thing, namely he must be convicted and sentenced to imprisonment of 2 years. Then there is an automatic disqualification from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release. He is convicted, he is sent to jail, and he is released. After 6 years, the ban continues for 6 more years from the date of his release. There are two parts of subsection 3 of Section 8. He must be convicted, he must be sentenced, and he must have undergone the sentence. In that event, when he is released 6 years from the date of release, he is disqualified. The disqualification persists and he cannot come out at all. To mellow down this situation, Section 4 was introduced by amendment, and it would say, notwithstanding anything contained in subsection 1 and subsection 2 or subsection 3, a disqualification under either subsection referred to above shall not, in the case of a person who, on the date of the conviction, is a member of parliament or legislature of state, take effect until 3 months have elapsed from the date or within that period an appeal or the application or revision is brought in respect of conviction or sentence until that appeal is disposed of by the court. A new concept was introduced by amending section 8 by introduction of subclass 4. what subclass 4 says is that notwithstanding the conviction, notwithstanding the commission of offences set out in classes 1 and 2, notwithstanding that he has filed an appeal and obtained stay, that during this interim, and he shall not be disqualified, he shall be continued. This was challenged. The virus of this was challenged in Lily Thomas. Lily Thomas, the Supreme Court has decided the matter in 2000. Lily Thomas is Lily Thomas is decided. I'll just a minute. I'll come to this. And this is 2013, and the Supreme Court held that it is beyond the power of the Parliament to legislate like this in terms of articles in the Constitution. It was struck, the amendment was struck down, and it is held to be ultra vires. Therefore, Section 8(4), which modified or subdued the rigor of Section 3 of Section 8(3), and that provision which nullified or neutralized the power under Section 3, namely automatic disqualification, automatic suspension, and the resultant vacancy for held of the seat held by that convicted person. All these things are now in this condition, namely Section 3 is valid, Section 4, which, as I said, reduced the rigor of Section 3, is struck down. The resultant situation is that by reason of Section 8(3), the moment conviction is entered, as for example, the case is called at 2 o'clock and pronouncement is there, says he's suspended. Right from that moment, 2 o'clock in the afternoon, the disqualification starts, and as a result, the seat becomes vacant. This is the situation which is happening now. Now we'll have to see what are we'll have to see the other nuances of the Constitution, and the Schedule 10, Articles 190, 191, 192 of the Constitution, occurring in Part 3 of Part 6 of the Constitution, and we have to see Schedule 10 of the Constitution of India, and the score that 102 and 191(2) are referred to in Schedule 10. Then we have to see Section 8 of the RP Act 1951, which deals with disqualification and conviction in certain cases. Please, as we have to analyze the provisions of Section 8, one has to see Section 8 has Class 1, Class 2, Class 3. 4 has been struck down and held ultra vires. In Class 1 of Section 8, there are various provisions like A, B, C, D, E, F, G, H, I, J, K, L, M, M1 and M2 of the RP Act, which serve as the storehouse of grounds to disqualify. In ever so many grounds are provided in Section 8(1)(a) to 8(1)(m) and M1, M2 of the RP Act, which would enable the courts to disqualify, or Section 3 to operate by itself to disqualify a person. I think we have heard 2 days or 3 days ago, the learned senior counsel of the Supreme Court, if I am permitted to name him, Mr. Kapil Sibil, the learned senior advocate, said there is no need for any agency to declare that he is disqualified. There is an automatic disqualification and automatic vacancy caused by reason of the conviction entered by the criminal court. The resultant situation is law operates by itself. There is a fiction introduced by Section 8(3), which says that if a man is convicted, from the hour of conviction, he is disqualified, and from the hour of disqualification, the seat has become vacant. The resultant situation is the Secretariat of the Parliament can say that that seat has become vacant, and it can take steps to fill it up also. Now we'll have to see Section 8(2). Section 8(2) consists of provisions A, B, and C, which enumerate the offences which center around public morality. It's an offense against the society. It's an offense against the public morality. It's an offense against the way in which the life and our way of life is adjusted. And that we'll have to see by reading Section 2 itself, namely, a person convicted for contravention of any law providing for prevention of holding and profiteering, or any law relating to the adulteration of food or drugs, or any provision of the Dowry Prohibition Act, and he is sentenced to imprisonment for not less than 6 months, he shall be disqualified from the date of such conviction and shall continue to be disqualified for the further period of 6 years since his release from conviction. We have read in section 3, the period is he shall be the person is convicted of an offense, sentenced to imprisonment for not less than 2 years. Section 2 refers to 6 months. So varying extents of conviction period are provided in section 2 and 3. 2 insists on, if a man is convicted for 6 months, then 6 months plus another 6 years he is disqualified and he cannot contest at all. And in the case of clause 3 of section 8, it is 6 plus 2 years. In the case of clause 2, 6 plus 6 months, 6 years and 6 months. And in the case of clause 3, it is 6 years plus 2 more years, 8 years he is suspended. The rigor of representation, in fact, actually, when we had the election commissioner, Mr. Sheshan was always saying that section 8 provides for all these things. We do not know how to implement it, and we are not implementing. Therefore, we have certain problem in deciding this issue, and it is for the parliament to intervene and enact. And this is perhaps one of the reasons when this provision 8.3 is staring at us for all through the year, but it was only when Navjot Singh Sidhu was convicted. This is an extraordinary case. Navjot Singh Sidhu's case is, I'll give the citation. Navjot Singh Sidhu's case is AR 2007 SC 1003 or 2007 2 SCC 574. In this case, he has committed an offence from entering the parliament or legislative assembly. Order of conviction should not be suspended. It is not permissible. The law declared in Navjot Singh Sidhu's case is, it is not permissible for court to hold that in order to prevent any person who has committed an offence from entering the parliament or legislative assembly, the order of conviction should not be suspended. So this was a situation where he obtained an extraordinary case, was even conviction was stayed. In the case of Mr. Navjot Singh Sidhu, he resumed his position and he continued to work as a representative of the people, and he served as a member of the parliament. When the moment Supreme Court convicted him, he tendered resignation and then he went to jail. This is one way of looking at it, by saying that the period of 6 months, 6 years and 6 months obtaining in class 2 has certain aspects which are addressed to the public morality, and section 8.3, which on conviction, the member of the parliament will be debarred for 2 years by way of imprisonment, and after his release, when he comes out of the jail, he is debarred from contesting the election for a period of 6 years. The total period of disqualification is for the category coming under class 3 is 6 plus 2, 8 years. Now we'll have to see what are this. Section 8 stipulates that a person convicted of an offence and sentenced to imprisonment for not less than 2 years, other than any offence referred in classes 1 and 2. We are excluding classes 1 and 2, but we are coming to shall be disqualified from the date of such conviction and shall continue to disqualify for a period of 6 years since his release. As I stated earlier, section 8.4 was struck down as ultra-virus, and in Lily Thomas' case. Then we'll have to see what are the other decisions. Granting bail, the law declared under section 8 in regard to the suspension of the sentence is the following. Granting bail or suspending sentence does not amount to stay of conviction. Kindly see, Supreme Court has clearly laid down in AR 2005 SC 688 that granting bail, in the present case, the member of the parliament has been granted bail for 30 days to enable him to approach the appellate court or the revisional court for purpose of getting relief against the conviction. And the law is granting bail or suspending the sentence does not amount to stay of conviction. There are two parts in section 8.3. One is conviction, the other is sentence. Sentence is the executory part of the conviction. The conviction is one that he is condemned, he is held guilty of the offences under the RP Act, they are called electoral offences, and he is convicted under that. Conviction is of greater dimension, greater severity, and greater application compared to the sentence. Sentence is the executory part of the conviction, namely, he is sent to jail. And the period is 6 months to 2 years, up to 2 years is 8(3), and 6 months is class 2. So therefore, if a man is convicted and sentenced to the term of to suffered in jail, the fact that sentence is suspended, the sentence is stayed, does not remove the disqualification. He cannot maintain an election dispute also under section 81 class 1. He cannot continue to attend the parliament. He cannot continue to attend the legislature. He is debarred from entering the parliament and the state legislature as long as the conviction stays, or as long as the conviction is not suspended. It's only in very rare cases, as I stated earlier, it's in Navjot Singh Sidhu's case, the conviction was suspended. It's an extraordinary case. Then the other law you declared is specific order of staying the conviction alone will operate as staying conviction. This is the law declared in 2007, volume 9, SCC, page 330. Stay order of conviction alone renders the conviction non-operative. Supreme Court has held that if the conviction is not stayed, nothing happens. Disqualification persists, disqualification continues. But the law further says, stay order of conviction alone renders the conviction non-operative. What is non-operative? Its effect is not there, the rigor is not there, the consequences do not follow. Namely, he shall refrain from entering the parliament. He shall not participate in the parliament. He shall not file the election petition under section 81(1). He cannot do anything saying that I was a member of the parliament, I am exercising that power. All these powers are taken away, and he is denuded of all the privileges, powers, and benefits of a member of parliament, and all that he can do is blame himself and his fate. They kindly see the next decision that must be taken note of is B.R. Kapoor versus State of Tamil Nadu, reported in 2001, 7 SCC, page 231. This law declared in Kapoor's case is that disqualification remains in effect and the order is effective from the date on which it was imposed. It is stated earlier also in the earlier edition, particularly in Lily Thomas and in Navjot Singh Sidhu. But the law is clearly laid down in Kapoor to say that disqualification remains in effect, not altered, not diluted, not reduced, the rigor is not reduced, and the order is effective from the date on which it was imposed. But as I stated earlier, in the latest case, if it was the pronouncement was at 2 o'clock, it operates from 2 o'clock, is law declared. So the situation is that this rigor of disqualification is not reduced, is not in any way altered unless the conviction is stayed, and disqualification remains in effect and its order is effective from the date on which it was imposed. Then we'll have to see whether the Parliament had passed, as I stated in the beginning, Parliament had stated that section 8(4) has been brought on the statute book by reason of amending the provision of section 8. And what was the effect of section 8(4)? What is the effect? Because it is not there. I use the word past tense. What is the effect? Section 8(1), 8(2), 8(3) would deal with conviction, sentences, and its effect on the disqualification, the resultant effect of disqualification. 8(4), I'm repeating, I said it earlier, introduce immunity against the disqualification and certain contingencies. And the contingencies are already narrated to you. It should say that it will be for during the period of appeal, and for a period of 3 months, it will not be effective. That the Supreme Court held in Lily Thomas versus Union of India. This decision is reported in AR 2013 SC 2662, and also in Supreme Court cases, namely 2013 7 SCC 653. This decision is that once a member of parliament or legislature is disqualified by any law made by the parliament or legislature, his seat automatically falls vacant by virtue of 101(3)(a) and 190 clause 3(a) and of Constitution, and Parliament cannot make a provision as provided in Section 8(4) of the RP Act. And the Supreme Court has held Section 8(4) in Lily Thomas to be ultra vires. So the situation is this, namely, Parliament cannot make law to dilute the effect of Class 8(2) and 8(3) of the RP Act. The rigor of 6 months imprisonment and 6 years disqualification appearing in 8(2), and the rigor of 2 years conviction and suffering the sentence for 2 years, coming out of it for a period of 6 years, 6 plus 2, 8 years. This can never be diluted, can never be altered, can never be taken away from RP Act. Is the law declared in this Lily Thomas case. Now we'll have to see the law again became a little nebulous, and the matter was taken up to Supreme Court in Sarita Nair versus Hebe Eden. This decision is not reported in either AAR or SEC, but however it is reported in 2020 SEC Online Supreme Court 1006. The citation is 2020 SEC Online Supreme Court 1006. The name of the parties is Sarita Nair versus Hebe Eden. There, the question was the disqualification and conviction, the distinction between conviction and sentence. Fact noted that Section 8(3) refers to conviction and the disqualification commences from the date of conviction. Held, mere suspension of sentence by appellate and revisional courts without disturbing the conviction did not remove the vice of disqualification. On facts, it is held by Supreme Court that petitioner who could secure only suspension of sentence remained under disqualification in terms of Section 8(3). Mere fact that the returning officer overlooked correct application of Section 8(3) did not operate as estoppel or waiver under Section, or because of these laws do not operate as statutory provisions. See, there the question was there should be estoppel. The returning officer has not done this, therefore there is an estoppel against it. There is no estoppel against statute. It's the famous statement, and the waiver of the term conviction and sentence appearing in Section 3 is not different, is differentiated by Supreme Court to say conviction is different and sentence is different. Conviction is the mind of the court after assessment of the evidence and record, after hearing the parties and after looking into the provisions of law, enters the conviction and punishes him. The sentence or the punishment part of it is the executory part of it, and sentence is different from the conviction, is what the Honorable Supreme Court would say in Sarita Nair. This decision was rendered by Honorable Justice Bobde when he was the Honorable Chief Justice, and the accompanying judges were A.S. Bopanna, Honorable Justice, and Justice Ramasubramanian, the Honorable Justice of the Supreme Court. It's a 3-judge decision, and in this decision, not only the rigor of Section 8(3) is discussed and elaborated, but scope of Section 81(1), namely the filing of the election petition and the locus standi to file the election petition by a person who has suffered disqualification, came for discussion in Sarita Nair's case. It is there the candidate was convicted under Section 8(3), and the consequence was that he was not a legal candidate to contest the election or to present a petition of Section 81(1). The law declared by the Honorable Supreme Court is that convicted person under disqualification Section 8(3) is not a candidate having locus standi to present a petition under Section 81, Class 1 of RP Act. The High Court, having found the petitioners as disqualified, rightly did not proceed with the merits. The election petition was dismissed, and the matter went up to Supreme Court saying that at any event, petition should not have been dismissed. They could have passed orders on merits. The Honorable Supreme Court says that conviction under Section 8(3) not having been suspended or not having been stayed, the election petition is not maintainable, and he has no locus standi to present petition. This law in Sarita Nair's case is recently followed by a bench of same combination, namely Justice Bobde, Justice Bopanna, and Justice Ramasubramanian, in the case reported in Pradeep Kumar Sontalia reported in 2021, volume 6, SCC, page 523. This, according to me, is highly readable in the sense Sarita Nair was not intense in its application, was not so well detailed reasoning was given in Sarita Nair's case to reach the conclusion that unless conviction is stayed, that the disqualification doesn't disappear. In this case, the law declared is not only dwelling on section 8(3), but on section 80, but on section 152, which deals with the disqualification, and as also on article 191 and 190, as well as article 80, class 4 of the Constitution of India. This decision is virtually a treatise rendered by Justice Ram Subramaniam, was speaking for the bench. This decision would, you will kindly see, this is the case which I mentioned, the time is mentioned, which is the effective time. An MLA who cast his vote in an election to Rajya Sabha in the forenoon, 9:15 a.m. in the morning, on the date of election, that is on 23/3/2018, conviction of by a criminal court in the afternoon of 2:30 on the same day, resulting in his disqualification. The validity of the vote cast by MLA in the morning at 9:30, when he was disqualified at 2:30 by the court on the same day, is held to be invalid. Look at the ramification that is brought about by Supreme Court. He had voted at 9:15. At that time, there was no disqualification. He was free to vote. He had exercised his right of vote, which in fact is as a right given both under the statute and the Constitution. But the situation developed into a serious one by 2:30 p.m. when he was convicted of the offences coming under section 8(3) of the RP Act. The situation is 8(3) conviction prevails over what he did in the morning, namely at 9:15 p.m. when he voted. His right to vote is eclipsed by the fact that he was convicted and disqualified at 2:15 p.m. on the same day. This law is sometimes stranger than fiction. We will have to see, all of us say, the pronouncement of the man guilty and his conviction under section 8(3) of the RP Act cannot be retrospective from the 0 hours of the previous night, and it cannot take effect a minute earlier, a second earlier than the time of pronouncement of the judgment. The judgment is pronounced at 2:30 in the afternoon on the same day, and the rigor of section 8(3) and the import of section 81(1) of the Act disabled him from presenting an election dispute itself. That's why we say that law is stranger than fiction. The theory of the deemed fiction introduced into section 8(3), namely the disqualification takes effect from, I think they have not elaborated it, almost from the date of complaint. That may not be correct, but situation is that morning he had voted and that vote is invalidated, is the declaration of law. This is a beautiful judgment, and the validity of the vote cast by MLA in such circumstances was challenged, and by the defeated candidate, that is the appellant, namely Pradeep Kumar Santalia, and the contention was that MLA's conviction and consequential disqualification must be deemed to have commenced at 0 hours previous midnight. All of us remember that in the insurance industry, a policy is issued effective from tomorrow night. The premium is taken today. Section 64, Class B of Insurance Act 1938 says that the liability of the insurance company, the insurer undertakes to cover all the risks from the time of receipt of payment of premium. The payment of premium could be by cash. The payment of premium could be by check, could be by deferred payment, could be by arrangement of bank guarantee for fleet of buses are there, VRL buses are there. Insurance can be renewed by a credit guarantee which is provided in the continuing guarantee given by the bank, and that will continue. Section 64 VB says that against receipt of premium, the insurance company assumes risk. The law that is holding the field today in Sunita Rati is that, Supreme Court decision, is that the insurance company can not only stipulate the time of commencement of the risk, but also can stipulate a date later than the date of payment of this. The reason is this: there was no assistance given by the claimant's advocate or by the owner's advocate before Supreme Court when it declared the law that insurance company can introduce the time of commencement of the risk and date of commencement of the risk, notwithstanding that the premium is received by credit guarantee or a guarantee issued by the bank or by cash payment on the previous day or by check issued on the previous day. Law has suffered in the case of Sunita Rati because there was nobody to represent the cause. But here in Pradeep Kumar Santolia, the law was fought to the bitter end by saying that the validity of the votes cast by MLA in such circumstances that is challenged and the defeated candidate, the conviction was later in the point of time, therefore it cannot. Supreme Court held that, I do not know what provision of law they have held it, that if I actually pay the premium today afternoon, at least it must start from that time. The Supreme Court says it starts from the previous midnight for election. And for insurance company, the Supreme Court says it comes from the next day. This is where the law has its own way of laughing out and makes us laugh at it. Then the resultantly, the vote cast by MLA at 9:15 and 23:10 would be invalid. The correctness of decision is not for discussion at the moment. We are only saying that 8:3 takes effect from the time of pronouncement, not merely the date. Okay, the word date is capable of meaning the point of time when the event, that is conviction hearing, took place rather than the whole day. Held, vote cast by MLA in the forenoon of at 9:15 a.m. on 23 could not be treated as valid as could not be treated as and sentence. Here is the catch. The word date is capable of meaning the point of time when the event, that is the conviction therein, took place rather than the whole day. Held, vote cast by MLA in the forenoon of 15 could not be treated as invalid on account of conviction sentence passed against him by criminal court in the afternoon on the same day. To hold that MLA stood disqualified even before he was convicted. I think what the previous head note was wrong, and this head note correctly says to hold that MLA stood disqualified even before he was convicted would grossly violate his substantive right to be treated as innocent and proved guilty. A conviction under penal law cannot be deemed to have effect from a point of time anterior to the conviction itself. On the same analogy, Sunita Rati could be as annulled, but that's not the issue today and not a matter for discussion. Then kindly see 191 class 1 came up for consideration and it fell for determination along with section 8.3 of the RP Act 1951. Supreme Court has said, interpretation of statute, subsidiary rules, anomaly, ambiguity, absurdity, hardship, redundancy, or repugnancy, interpretation reducing provision to absurdity, avoidance of doctrine of maxim, de facto invocation, words and phrases, date, the date of conviction, election, conduct of elections rules, 95. The main issue was whether the vote admittedly cast in the election is valid or not, and Supreme Court holds that it is that's valid. So in this Santalia's case, the law declared in Sarita Nayar's case is discussed and endorsed to say that his disqualification is prospective and not retrospective. Then in head note C, democracy and general principles, interpretation of election laws, the provisions of the election statute, mode of interpretation, the principles governing this are discussed. Section 8.3 is held by Supreme Court in Santalia's case, would achieve equity, and one of the fundamental principles that is to be kept in mind while interpreting the phrase appearing in section 8.3 of the RP Act is that in cases of this nature, the court is not dealing with a fundamental right or a common law right. It's an election dispute which lies in special jurisdiction, and hence it has to be exercised without importing the concept familiar to common law and equity, unless they are integrated in the statute itself. I think this decision reported in Santalia's case has a few more dimensions which can be exploited and applied to other cases by an active lawyer. Then the commencement of the world date, qua the insurance, is also discussed in para 42. The law declared in para 42 is that it must be remembered that the policy of insurance lies in the realm of contract. Therefore, the interpretation to be given to the terms of such contract would largely depend upon the intent of the parties, with a certain degree of latitude in favor of the party whose bargaining power is not equal to that of the other contracting party. Hence, it is not possible for us to adopt the interpretation given to the word, the date appearing in the contract of insurance. So they surmised by saying that the date given in an insurance policy to be operative from the next day is not possible to be given in the case of interpreting section 8.3 or article 190 and 191. The resultant situation is that if an MLA had voted at 9:15 a.m. that morning, and he was disqualified in terms of section 8.3 of the RP Act by 2:30 in the afternoon by the court of competent jurisdiction, the invalidity, the disqualification that flows from conviction at 2:15 is operative from 9:15 when he had voted. Look at the gamut of the interpretation. The limit of interpretation is propounded by the Supreme Court to say that in the matter of statute law, namely 8.3 and constitutional provision, law is different, and in the realm of contract of insurance, the law is totally different. Well, say the Article 141 allows us to respectfully bow to this and abide by the law declared by the Supreme Court. Well, in this situation, now we come back to square one. What is the disqualification that a man suffers if he is convicted by a court of competent jurisdiction, and what are its effects on the rights of an elected candidate? We'll have to run through the whole scenario. An elected member has a term to serve. He is accountable only to the voters. He suffers a social audit by his voters who evaluate his services and say either tick him off as a good servant to the people, or a man who served himself but not the people and give him 0 marks. And in the social audit by the voter, in the next time when he comes for seeks re-election, he can be denied the right to, he can deny the favor of a vote from the voters, and he can be defeated in the election. This is one aspect of social audit as far as elected members are concerned. Now, if a man takes a vote and gets elected from the constituency on a particular ticket, on a particular representation by a political party, this is where Schedule 10 operates. He cannot, beyond the period of 6 months, change his identity. If he's an independent member, after lapse of 6 months, he cannot embrace another political party and become a member of that party and say that I am with the crowd. He cannot say this. This is what is mentioned in disqualification, clause 6. And the order of the speaker in this behalf is final. And the finality clause in paragraph 6 of 10th schedule was called in question in that Zachulu's case. Zachulu is the respondent and Kilolo Hawaito was the petitioner. There, the Honorable Supreme Court held that the power of judicial review is not limited, and they are amenable to judicial in the matter of how the law is applied, how the law is interpreted, and judicial review is certainly there. All of us remember an earlier decision rendered in the year 1995 in the case of Election Commissioner Gujarat versus Union of India. The Election Commissioner gave a schedule and fixed the time. And according to the Election Commissioner, this is unalterable, no court could interfere, and the heavens falling down or hell losing itself down, the date cannot be altered, was the stand taken by Election Commissioner Gujarat. The Gujarat High Court held otherwise. No, the exigencies demanded the postponement or refixing of the date, and it interfered with the schedule of events pronounced by the Election Commissioner. The matter went up to Supreme Court at the instance of the Election Commissioner, and the law is laid down in 1995, Volume 3, Supplementary Volume 3, page 643, to say that in paragraph 8 it is stated like this: there are no unreviewable discretions in the constitutional dispensation. Justice Venkatachalya and Justice Mohan were the two judges who held the law likewise in paragraph 8. The beautiful statement of law has come to stay, and it is quoted often by all of us, saying that there are no unreviewable discretion in the constitutional dispensation. 329 is a constitutional dispensation authorizing the calendar of events to be published by election commissioner, and nobody can interfere with the process of election once it is started. Supreme Court held, yes, it is true as far as that proportion of law is concerned. But if there is an occasion which demands judicial review, which demands intervention by the court, then there are no unreviewable discretions in the constitutional dispensation. This is the one exception that we have found in the matter of the election law being interrupted. So the sum and total of today's discussion is that the disqualification is coming by reason of conviction under section 8.3 is instantaneous. No agency is required, no notification is required to say that he is disqualified. There is no need to make any statement that a person convicted of an offense enumerated in 3 is disqualified from working any further, and in view of this Sontala's case, from the 0 hours of the case or from the date of pronouncement of the order. Now the situation is this: can this be remedied? And what was in the offing in the year 2013? When the law was laid down in Lily Thomas in the year 2000, and the law was declared that 8.4 is ultra-virus, there was an attempt made to bring in an ordinance. We all recall what we saw on the TV screens, that the political bigwigs had found themselves comfortably seated in a platform, and somebody they brought the one sheet ordinance promulgated by the President of India to say that notwithstanding the judgment of the Supreme Court striking down section 8.4 as ultra-virus, the ordinance is issued to re-enliven and bring back the life into section 8.4. And one of the members of the parliament, he said that when the court says that the law is bad, we should not try to overreach the law declared by the Supreme Court under Article 141, and it's appropriate that we respect the law declared by the court. And he caused magic by saying that this is one sheet, I will make it into 2 sheets by cutting it across. So that was the situation where our law has continued to be the same right from 2013. 8.4 is struck down, 8.3 is supreme. Now, in sum, no agency is required to disqualify. No extraordinary gazette is to be issued to say that man is disqualified, he ceases to be a member of the parliament. And as Mr. Kapil Sibil put it, automatically the position held by that member of the parliament or that member of the legislature becomes vacant and available for the election commissioner to notify the further process of election. In sum, we can conclude by saying that section 8.3 operates by itself. Section 190 and 181 would operate by themselves. And the whole situation in a democratic country like India, the law is supreme and law alone reigns. The situation today is that thanks to the enactment like RP Act, which is self-contained, which was there, section was there right from beginning, and we had not used it. Today, we are in a position to say that law has prevailed and our fictions have disappeared. Our concept of the agency to intervene, the agency to declare, the agency to promulgate, the agency to gazette and publish, all these things are not there anymore. And if a man is convicted of electoral offences enumerated in section 8.1, 8.2 or 8.3, the only resultant situation is that he is disqualified, and it is instantaneous, not even for a minute longer than the time of pronouncement of the judgment. And till he gets an order of suspension, it operates. If he does not get an order of suspension of the conviction, the disqualification continues and he is there in the jail. And or if unless the conviction is the sentence is also not straight. If his sentence is straight, he would not there. Afterwards, he goes there, and the moment he is released, from that time, the suspension again is for 6 years. So 6 plus 2 years, 2 years conviction and 6 years moratorium. The resultant situation, the man's political